Right. Good afternoon. It is May 29th. We are in for this is our weekly installment of the Economic Justice Law Review Weekly Scholarship Digest, where we discuss race, economics, and law scholarship that's published in the journals all around the country, bring them to one place and become the repository for those for that scholarship that references race, economics, and the law. Well, actually, it doesn't have to specifically reference race, economics, and the law because it is our belief that almost every racially subordinating circumstance can be described in economic terms. It can be described as in respect of the degradation of an idyllic, free, and fair marketplace under the neoclassical conception. In other words, the capitalism or the free market ideology that we were all taught in undergraduate and that's bandied about, that supports Gary Becker's Economics of Crime, Race and Discrimination, and all that, assumes four things. There are four assumptions to this free and fair meritocratic market that's supposed to distribute goods and services justly and efficiently. One, that everybody is a profit maximizer. Two, that everybody can enter or leave any lucrative market that they like or non-lucrative market that they don't like. Three, that there is perfect market information. Everybody knows everything about everything. And that there are no transaction costs like taxes or pollution or crime or anything or accidents. So we know that that the idyllic free market does not exist, no matter how much the free market fundamentalists try to base policy on it. We recognize that not only are humans not necessarily profit maximizers, not only do humans have capital gaps between each other, not only are humans certainly subject to imperfect information and not able to store all that is good, and we know that humans deal with taxes and environmental pollution, torts, and all that good stuff. We know that in America, if we want to describe structural racism in an economic manner, all we have to do is recognize that profit maximization or market engagement is asymmetrical with respect to race. That market competition, the imperfections of market competition, right? The capital gaps, the human, social, political, financial capital gaps represent asymmetrical or racially asymmetrical market competition. We know that the paucity of information available to black folks and also the stereotypes about black folks reflect racially asymmetric market information. And we know that the maldistribution, or we can recognize the maldistribution of criminal law enforcement, tort damages, environmental pollution, racialized health care, regressive taxation. All of that can be assigned to the rubric of asymmetrically distributed transaction costs relating to race. So those are our four components. Those are our four components of an unfair market, right? And so again, if Gary Becker argued, and a lot of neoliberals and neoconservatives argue or contend that a free market will end racism without government interference. That could be true because there is no such thing as a free and perfect idyllic market. So to the extent that the free market, or I'm sorry, to the extent the market has asymmetries with respect, racial asymmetries with respect to profit maximization, competition, information, and transaction costs, then that market will perpetuate racism. If a free market will end racism, an unfree market will perpetuate it. I think that's plain and simple enough. Let's get to the scholarship. Who am I? Andre Smith, Dre Smith. You guys remember me, 15 years at Penn State, Florida International, Widener, and Howard University School of Law. Shout out to all my colleagues, and especially those that are interested in racial economic justice and the law. All right, so featuring this week, we're going to feature three pieces this week, as we normally do. Eidelson, Benjamin Eidelson from Harvard, got your piece out of the Yale Law Journal. Issa Kohler-Hausmann from Yale, got the heavy hitters, got the top 5 or the top 10 schools in the place. And when we talk about top 5 or top 10, top 5 or top 10 all-time critical race theorist pioneer Charles Lawrence has dropped a new article that's published in the Harvard Law Review reviewing Jennifer Eberhardt's book on implicit bias, right? So those are the 3 papers that we're going to identify or feature this week. Let me remind you of some of the fantastic papers that we have done in weeks past. Last week was a book cipher, right? Last week we had 3 incredible books by scholars and journalists dealing with race and economics. Number 1, we did William A. Darity, Sandy Darity out of Duke, and Kirsten Mullen, From Here to Equality, Reparations for Black Americans, right? A new book published by the University of North Carolina Press. We also featured Gene Sperling from the Council of Economic Relations, Council of Foreign Relations, longtime veteran in the most higher echelons of government, has written a book called Economic Dignity, right? That's published in 2020. And on his label mate on Penguin Random House Books, Isabel Wilkerson. You know Isabel Wilkerson, Pulitzer Prize winning journalist, author of The Warmth of Other Suns, has a new book coming out this October called Caste, The Origins of Our Discontents, 2020. Caste, The Origins of Our Discontents. So those are the books that we reviewed last week. Each of them definitely worthy of our recognition and our attention. In weeks past, we've talked about Terry Dobbins Baxter's Dying for Equal Protection, Joe Weaver Lenz, Gerard Uspan, Anya Prince and Daniel Schwartz, Noah Zatz, Megan Berry, Jason Bent. I want to keep bringing up his paper. I just think that is, along with Ruha Benjamin's Race After Technology, the New Jim Code, I'm totally convinced, those papers are totally convincing to me that the new issues for race, or the biggest issues for race and economics, are going to take place in the cyber world in the coming future. And not just economically, but with law enforcement. And so books by Ruha Benjamin are fantastic. And also Jason Bent's Is Algorithmic Affirmative Action Legal? Woo! Fire right there. Paul Malika, Peter Nicholas. Peter Nicholas has a fire paper on jurisprudence called Reconstruction. William Sable, Bernadette Atuahene on predatory cities. Fantastic work. Again, if you're interested in racist and regressive informal taxes, formal and informal taxes, Bernadette Atuahene's Predatory Cities is fire. California Law Review 2020. Also, Beth Colgan's Economic Liberty and Criminal Justice in the Harvard Journal of Law and Public Policy. Some very fantastic papers. There's others that I've left out, but to me those have been some of the most impressive, and so I wanted to keep mentioning them week to week so that all of us as scholars are aware of them and can use them in their work. So let's start with this week. We have Benjamin Eidelson, right, from Harvard, on affirmative action and the definition of individuality, right? So we're dealing, as a matter of fact, both our first 2 articles are from our friends at the highest echelon of law schools at Harvard and Yale, dealing with the definition or the philosophical content of words, right? Again, if we're in a textualist regime, as this Supreme Court is insisting upon, then the definition and content of words used in the text, in the statutes, in the Constitution are of extreme importance if we're going to be interpreting it, if that's in fact what we're doing. So Eidelson is dealing with the question of individualness. Individual. The court makes the point that affirmative action or colorblindedness is the way in which, colorblindedness is the way in which we treat people as individuals, and affirmative action is apparently not, according to the conservative justices. Professor Eidelson takes that to task. He argues, what does it mean to treat someone as an individual? And he criticizes the court for not actually exploring the question, to reciting that as a slogan over and over again for its rhetorical power without actually delving in to the meaning of what they're saying, to treat everyone as an individual. And he also offers how treating someone as an individual should, in many respects, reject colorblindedness. As a matter of fact, so this is my review of his paper, or at least my description of his paper. Eidelson explores philosophically what it means to treat people as individuals as it relates to the Equal Protection Clause, proposing that autonomous individuals, he does a big thing about autonomy, often want to be treated in respect of their race as a social fact. Also criticizing the court for not explicating what is meant by the statement, and suggesting that such failure supports the critical claim that courts work backwards when writing judicial opinions, right? He's basically saying, I mean, these are supposed to be the best of the best, right? These guys graduated from Yale and Harvard at the top of their class as well. So for them to not think seriously about what it means to be an individual or treat people as an individual suggests that they are offering slogans, suggests that they, from a critical legal studies, not just critical race theory, but from a critical legal studies, that they're working backwards, that they've already decided what they want to do, and that they're going to come up with a judicial opinion that fits, right? That they believe fits the best, or writes the next best chapter. Again, he cites Dworkin, so I feel at liberty to cite to Dworkin in this piece. I believe he has a PhD in philosophy and has written a book called Disrespect and Discrimination. So again, he is very in tune or concerned about the content, the definition, the scope of words. Discrimination. What does it mean to be discriminatory intrinsically, legally, what have you? And the same here, what does it mean to be an individual? What does it mean to be autonomous, right? And again, he points out that an autonomous individual would often want to be respected for the things about them, including their race. I want to say this paper was anticipated by, I want to say, Angela Onwuchi-Willig, who wrote a paper maybe 10, almost 15 years ago about and maybe it's Devin Carbot, I'm not sure, but it was a paper about how a personal statement in an application to law school would be incoherent if you left out their references to race and the things that they've overcome in their lifetime, that it wouldn't make sense, right? That their individualism would be tattered and scattered, right? And so Benjamin Eidelson is offering us philosophical foundations for those who believe in that, who believe that is the proper retort to the claim that affirmative action does not treat people as individuals, and that colorblindedness does. Fantastic paper. Was about affirmative action. So economically speaking, we say that affirmative action in higher education combats racially asymmetric market competition in the sense that admission to elite colleges and universities offer greater opportunities towards increasing one's human and social capital, right? The things there, you have more opportunity at the most elite schools than other schools to fulfill yourself, right? And also the people you associate with will have greater amounts of capital and are be able to be leaned upon when the time comes. And so because the same information that Harvard offers is largely available elsewhere, not just from a library, the old Goodwill Hunting thing, but now because of the internet, affirmative action in education counterintuitively does not really substantially combat racially asymmetric market information available to black people, right? Now, the idea that black people are inferior or for whatever reason don't deserve affirmative action to the extent they are faulty, based on false images or ideas about black people and our worthiness, then those would reflect racially asymmetric market information about black people, right? Remember, when we talk about racially asymmetric market information, there is that which is available to black people and available about black people. All right. Similarly, Issa, Kohler-Hausmann, what's the point of parity? Harvard, Groupness, and the Equal Protection Clause. This is published in the 115th volume of the Northwestern University Law Review Online. I'm sorry, Benjamin Eidelson's paper, Respect Individual and Colorblindedness. That's in the Yale Law Journal for this quarter. Issa Coleman-Hausmann, her paper is in the Northwestern University Law Review Online. Kohler-Hausmann explores sociologically what is meant by equal. In other words, if we're talking about equal protection of the law, what is being protected? What type of equality? What does it mean to be equal in that respect as it relates to the Equal Protection Clause, specifically in the context of the affirmative action suit against Harvard University's admissions policies, which disfavor Asian students with higher objective scores. She contends that conditional group parity as the content of equal protection fails to respect race as a social construction, fails to respect the equal protection tiers which recognize and ranks race in relation to other social constructions, and is also failing to respect the university's permissible desire to achieve whatever benefits they sincerely believe diversity offers. In other words, bottom line, this is a lawsuit that was raised specifically to dismantle affirmative action. The lawyers that promote it admit as much. However, the tact is by taking Asian students and showing that they are discriminated against by affirmative action policies because their performance, from objective criteria, is far and above the average white student or black student, and yes, they are admitted at lower rates. And so Kohler-Hausmann criticizes their description of equality, where everyone in a group should have the same probability of obtaining whatever they're seeking based on the objective credentials. However, Professor Kohler-Hausmann says that ignores the social construction of race entirely, right? And so to ignore the whole social construction of race, you are basically ignoring the university's desire to have a diverse student body, which the court has said is permissible, that you just can't do it any other way. If you want to have more black students in your university, then you're going to have to accept those who have fought through or against racism to get there, and accept that their scores are going to be lower. You have to accept, as she does as a sociologist, that the reason that black scores are lower than white scores, are lower than Asian scores, are because of the social construction. It's not natural. It's not innate. It's not genetic, right? So if you accept that race does not exist in a biological or genetic context, then you have to assume or believe that the differences between race are socially constructed just as race is, right? So she says to ignore that social construction is basically unintelligent, and it cannot support an equal protection clause understanding of what equal means. However, she is also disappointed that no one in the case, and nobody yet, has dealt with what is the context of equal, what is the context of equal protection that allows affirmative action and yet calls out discrimination against high-performing Asian students, right? This group conditional parity shows how Asian students are outperforming and then not getting in, and that could be a process of racism. It can be a process of discrimination. It can be a failure of equal protection. At the same time, black students are getting in with less credentials than those Asian students, right? So what is the principle of equality that we're looking for, and specifically that protects both sets of people. And again, I offer asymmetrical market imperfections as a proxy for structural racism, and we can show that again that to the extent the market or these rules, Asian folks as a social fact face more racial asymmetries in the marketplace than white folks do, then that would justify equating or leveling the playing field on their behalf by offering quote unquote special treatment, or actually putting their applications in the proper context. Again, affirmative action in higher education. She contends that conditional group priority as the content of equal, or we already went through that. Again, affirmative action in higher education combats racially asymmetric market competition in the sense that admission to elite colleges and universities offer greater opportunities towards increasing one's human and social capital. Because the same information is largely but totally available elsewhere, affirmative action in education counterintuitively does not substantially combat racial asymmetric market information available to black people. All right. So two wonderful papers, two very philosophical, sociological papers dealing with the content, with the definition of equal and the definition of individual as it relates to the Equal Protection Clause, right? And we want our theories, again, my asymmetrical market imperfections, for all of those who want affirmative action, who want the Equal Protection Clause expanded through interpretation. We have to pay very, very specific attention to papers such as these. And these two are two very young scholars. Professor Eidelson and Professor Kohler-Hausmann are two very, very young scholars, so we're rooting for them as far as their advancing critical legal studies, as far as advancing a wider understanding of the Equal Protection Clause. Last but not least, certainly not least, we have the pioneer, Charles R. Lawrence, out of University of Hawaii, and Mary Matsuda. Oh, let me give a shout out to Kim Ford Mazrui down at Virginia. I believe he is included as someone who's acknowledged in Benjamin Eidelson's paper on individualness, right? So shout out to Kim Ford. All right, back to Charles Lawrence out of University of Hawaii, Implicit Bias in the Age of Trump. Speaking of Hawaii, who did we do a couple weeks ago? We did Nick Merkay and Pamela Strand. I'm pretty sure they wrote the paper while they were both at Creighton. But now that Andrea Freeman has left Hawaii to go to Berkeley, I believe, Nick Merkay has left Creighton to go to Hawaii. So shout out to Nick. Shout out to everybody out on the island. So again, Charles R. Lawrence, Implicit Bias in the Age of Trump, reviewing Biased, Uncovering the Hidden Prejudice That Shapes What We See, Think, and Do by Jennifer L. Eberhardt, and that is published in the 113th volume of the Harvard Law Review, page 2304 in 2020. That's the review, not the book itself, right? You can get the book online, Jennifer Eberhardt's Biased, Uncovering the Hidden Prejudice That Shapes What We See, Think, and Do. All right, so since this is the review of a review, we're going to keep this short, but we're just going to definitely say that implicit bias, as discussed by both Eberhardt and Lawrence, reflects, economically speaking, it reflects racially asymmetric market information, right? Untruthful information about black individuals instead of the lack of truthful information available to black people, right? Racially asymmetric market imperfection has two components. One is the lack of truthful information available to black people, and also the plethora of untruthful information available about black people. In other words, talking about racial stereotypes and the myth of black inferiority. And so those things underline the implicit bias, right? That the things that we've been inundated educationally through media, through family and whatever, has given us an implicit bias against people of color, or implicit bias against black people. Even black folks hold this against other black folks. That is referenced specifically, as we talked last week, in Scientist. not Thomas Edison. What's the brother? The theory of relativity. Einstein, Albert Einstein, when he did a lecture at Lincoln University, and it's published in the NAACP Crisis magazine. He talks specifically about how those subject to white supremacy assume the prejudice estimate of the majority themselves and come to regard each other as inferior. Right? So even Albert Einstein understood the wide implications or the deep implications of the myth of black inferiority, of implicit bias. Right? Now, again, interesting thing about Charles Lawrence, right? As an original critical race theorist, his shtick or his specialty is narrative. Right? That again, if we go back to Eidelson, who gives us evidence that the court is not actually proceeding from a premise to a conclusion, right? Or at least they're going from conclusion and then fitting the premises underneath, right? Which means all of it is BS, and that they're really dealing with narratives. Again, harkening back to Dworkin and these serial chapter writers, and Charles Lawrence is consistent with that in talking about story and narrative all over the place, about the judicial opinion, about the law. Everything is a story. It's all a narrative, and he explores it in classic critical race theory fashion. Big ups to Charles Lawrence. CRT Pioneer applies the concept of the story or the narrative as it relates to implicit bias in law and elsewhere. So again, 3 fantastic papers that have been published in the top journals, in the top 10 or top 20 journals. So they are ripe for the citing. Right, so all of you race, economic justice, and law scholars, run out to Westlaw or whomever. Get Benjamin Eidelson's Respect, Individualism, and Colorblindedness, 129 Yale Law Journal, 1600. Get Issa Kohler-Hausmann's What's the Point of Parity? Harvard Groupness and Equal Protection Clause, 115 Northwestern University Law Review Online. And also Charles R. Lawrence, Implicit Bias in the Age of Trump, reviewing Biased, Uncovering the Hidden Prejudice That Shapes What We See, Think, and Do by Jennifer L. Eberhardt. And the law review article, not the book, but the law review article is available on 113 Harvard Law Review 2304. So, appreciate y'all for stopping by. We'll be back next week, hopefully on Wednesdays, but before the week is out, every week, we're going to do this weekly scholarship digest from the Economic Justice Law Review. This is Dre Smith signing off. See you next week.